a few of our partners from first of our LawTech Hub Partner Series. We're going to have today Madeline Kelly from FB Rice, and in the second half of this, Mark Allen from Aperion. It's still Aperion, right? You're on mute.
We have changed our name, so we did a transaction earlier this week to extend our reach to Melbourne, and as part of that, we've adopted the name of the Melbourne firm. In the cut and thrust of a negotiation, we had to relinquish the name Aperion, but there were other benefits that we got. So if you contact me after this, it will be with a new email address, but I'll get Stephen to circulate that.
Sure. Mark, formerly Aperion. So let's Madeline take it away.
Okay, let me just share my screen. Can you see that?
It's coming up.
Gotcha.
Yep.
Actually,
okay.
Sorry, before you begin, would you like to know, would you like to know a quick preview of the companies that are on? Would that help?
Absolutely, that'd be great.
Yeah, apologies, I should have led with that. Maybe I'll start in alphabetical order, and Brian, I'm always going to pick you guys first.
Yeah, so I'm from Avoca, and we're a contract automation, negotiation, and analytics tool. So essentially we help lawyers, cut down the drafting time of contracts by removing a lot of that manual editing of a template and spitting out your first draft, in minutes rather than hours or days. Yeah, then we sort of go on to incorporate the full sort of contract lifecycle. So including, collaboration on the cloud, negotiation and trading drafts with counterparties all over the cloud. And then finally providing some very useful sort of analytics on the entire drafting process, as well as giving sort of managers more information to allocate resources more efficiently.
Okay, cool.
Great. Thanks, Brian. Shavin, do you want to do Build My Will?
Yep. Hi, so I'm Shavin. So I'm the founder of a company called Build My Will. Basically what we do is make it free and super simple for people to make a simple will online, and then optionally leave money to a charity or a nonprofit that they care about. So our partners are primarily charities and other nonprofits who we're trying to help sort of raise their bequest income. So that's our business. Yeah.
Slightly out of order. Ollie, you want to do Be Next?
Not a problem. My name's Oliver, and I work with a company called Be Next, who are looking at implementing smart legal contracts, which is, a fancy name for contracts as bits of software that sort of manage the business relationship in a more dynamic way than just spitting out PDFs and things that you can print. I'm sure you're all familiar with the idea.
Great. There's also InDigital, who we're recording this for. They're an indigenous startup who tried to capture like indigenous stories through technology. And we have Stu from Syncly.
Cool. Yeah, look, we're a data synchronization platform, so helping professional service firms move a piece of data from one technology to the other.
Okay.
All right, the floor is yours.
Okay, well, so I'm here to talk about navigating intellectual property, and I will just jump straight in and give you an outline of what I'm kind of proposing to talk about today. So first off, I will just tell you a little bit about FB Rice and who we are and what it is we do. And then I think it's always worthwhile having a think about why it might be worthwhile protecting your intellectual property. Why would you even consider doing it? I will then touch on an overview of intellectual property. So generally the common types of intellectual property and how they might be used to protect aspects of your company. I will just quickly go through the patent filing process so you get a sense of what's involved if you do actually end up going down the route of trying to file patent applications. And then finally, I will give you a couple of tips for working with patent attorneys so that you can get the most out of any of those initial meetings that you would have with them. So first of all, I'm Madeline Kelly. I'm a partner in the engineering group at FB Rice. My background is in electronic engineering and computer programming. So you might be able to tell I'm Irish. I moved to Australia about 8 years ago. I had qualified as a European patent attorney in Europe, and then I re-qualified as an Australian and New Zealand patent attorney when I moved to Australia. So I joined FB Rice, and FB Rice, it was established over 70 years ago, and we have offices in Sydney, Melbourne, Perth, and Brisbane. And we are a boutique intellectual property firm. And by that, I mean that we focus solely on intellectual property law. So patents, trademarks, designs, and some copyright. And we do it well. It's what we do. Unlike many other intellectual property firms in Australia, we're independent in that the firm remains under control of the partners and it's not publicly listed. Although we're one of the largest and successful IP firms in Australia, we've grown organically and carefully, and we remain committed really to high quality and client-focused service. Our attorneys collectively have experience and expertise across all areas of technology, and many of us are multi-jurisdictionally qualified, which kind of gives us a wide lens perspective when advising on global IP strategies. So why protect your intellectual property? Intellectual property can be among a company's most valuable assets. It can help build and preserve brand value and your reputation, and it can contribute significantly to company valuation. It's a good way potentially of generating revenue, for example, through assigning any of your IP rights or licensing them and generating licensing revenue from them. It offers a way of protecting research and innovation that you might be conducting, potentially to give you a competitive advantage over your competitors. And all of these benefits also help to attract investors and funding if that is something that you're looking to do. It also not only attracts investors and funding, but commercial partners, which might be helpful to take your business to the next stage. And IP can also, it's a good defensive strategy. If you've got patents, for example, in place, it can deter others from potentially moving into your area of the market. So the common forms of intellectual property, I'm just going to talk about the main ones really. And first of all, we've got trademarks. I'm sure most of you are familiar with what a trademark is. It's effectively a receptacle for your reputation. So it ties the goods or services that you're offering to you as the owner or originator of those goods and services. And you'll be familiar with lots of different trademarks for Apple or Google, Facebook, some of those that are listed there in that icon there on the screen. Now, trademarks must be able to distinguish your goods and services from those of other providers. So, for example, you wouldn't secure trademark protection for the word milk if you were selling milk, because clearly that's something that anybody who was selling milk should be entitled to use. It's not distinctive, and in fact, it's descriptive of what you're providing. So trademarks really, the best trademarks help to identify you as who you are and distinguish you from your competitors. Now, you can register trademarks even after you've used them. And although there are unregistered trademarks available, it's always advisable to actually register your rights because that gives you better protection. Copyright is the intellectual property right that helps protect literary and artistic works. And this also includes computer code. Now, copyright doesn't protect the idea itself, but actually the expression of it. And it needs to be in tangible form. And in order to attract copyright, your work must be original and that it can't be copied, and it must have some level of skill or input required to actually generating it in the first place. To enforce copyright, you need actually to be able to prove that somebody has copied what you've done. And the term for a copyright is generally, I mean, it changes from jurisdiction to jurisdiction and sometimes with different works, but typically about the life of the creator plus 70 years. So it's quite a long period of protection, but it can be quite limited. So for example, in terms of computer code, it's really protecting the expressed lines of code as opposed to the functionality of what the computer program is actually doing. Copyright in Australia and in many jurisdictions, you don't actually need to do anything. You have it by virtue of the fact that you've just created it and produced it in a tangible form. But generally, it's good practice to make sure you keep track of your copyright works. So for example, if you have code that you've generated, you want to be maintaining a register of some sort that basically keeps track of the versions of the code, who was involved in creating them, who had access to them when they were updated, that kind of thing. It can help down the track if you actually ever want to enforce your copyright. Form of intellectual property I will talk about is designs. So designs protect pattern, ornamentation, shape, or configuration of an object. So basically the overall look of it. So if you think of the shape of Coca-Cola bottles or the shape of sunglasses or the iPhone shape, they're the types of things that are protectable by designs. Again, it's a limited type of protection in that it only protects the look of something. So if you were to change substantially the shape, it would no longer fall within the scope of the design registration for the original shape that you'd sought. Design protection has different durations, so it lasts longer in different jurisdictions. So for example, in Australian design registration will give you protection for 10 years. Europe, you would get 25 years protection for design registration, and in the US, it's 15 years. Patents protect how things work, basically. You tend to have patents directed towards products, devices, methods, processes. They're not limited to the way something looks in the way that designs are. They are more about how it works, so the functional aspects of it. And again, if you think back to the way the code is protected by copyright, computer implemented inventions that just happen to be implemented in software are protectable by patents. And also worth considering is trade secrets. So in some circumstances, it may make more sense for you not to file a patent application, but to instead retain your knowledge of your invention as a trade secret. And situations where that can be particularly useful is where it's questionable as to whether you might be able to secure patent protection for your invention. So when you file a patent application, the application gets published, and that's effectively a description of how to perform the invention. When that's published, your application is still an application. It hasn't been granted yet, and you've no guarantee that you will in fact get a granted patent at the end of the day. But in order to actually be in with a shot of doing that, you need to disclose how your invention works. If there is any chance that perhaps you won't be able to get patent protection, and your invention is something that could be kept as a trade secret, it may be worth considering that as an alternative strategy. Now, if you have an invention and you wish to go down the route of filing a patent application, this flowchart or graphic here gives you an idea of the process that's involved. So essentially, the first thing you would do would be to get a patent specification drafted. And a patent specification forms the basis of your patent application, and it typically has a number of sections, a background section that kind of discloses what's currently being done, another section that talks about potentially the problems involved with the way things are currently being done, and a detailed description of how your invention overcomes those problems or provides for a different or alternative solution to the way things are currently being done. And that's the kind of scope of protection that you'd be seeking with your patent application. So that patent specification would get filed as an initial patent application, maybe as a provisional application in Australia. And once that's filed, it just sits there and nothing happens effectively for 12 months. But at the end of that 12-month deadline, you need to decide whether you wish to continue pursuing patent protection. for your invention. And if you do, you have to take further steps. So for example, if you're only interested in pursuing patent protection in Australia and New Zealand, you might then at that stage just file applications directly in those jurisdictions and prosecute them through to grant. On the other hand, if you are looking at seeking protection in perhaps 3 or more countries, it may be worthwhile considering filing an international patent application or a PCT application. And what that does is effectively holds open the option for you to file patent applications in one of about, I think it's 154 countries worldwide within the next 18 months. So you don't have to make that decision for a further 18 months. And that can be very helpful, particularly for startup companies that are looking for funding and looking to get more people on board, or perhaps test out the viability of their company and their inventions before really incurring significant costs in filing patent applications in individual jurisdictions, as is eventually required. Also, during that 18-month period, the International Patent Examiner will pick up your patent application and perform a search, and they'll issue a written opinion, which will give you an idea of prior art or prior solutions that exist out there, and give you a sense of the potential scope of protection that you might be able to get with your patent application. After that 18 months, which is effectively 13 months from when you start the process, you need to then make the call as to which jurisdictions you want to file patent applications in. And these need to be, for the most part, done on a country-by-country basis. So you might be filing a US patent application, Chinese patent application, and New Zealand patent application. Europe does have a regime whereby you can file a European patent application. And once that gets granted, you can kind of rubber stamp it through various jurisdictions in Europe selectively. But I guess the main point is here, at this stage, there's significant costs in filing each of those independent patent applications, and they then all go along on their own track of prosecution completely independently of each other. And that examination process will involve a US patent examiner, a European patent examiner, an Australian patent examiner, each performing their own independent search of your invention and issuing an examination report. And you will then get into a kind of back and forth with the examiner as you thrash out the scope of protection that you might be able to achieve in each of the jurisdictions. And it may be the case that you end up with a US patent, a European patent, and an Australian patent, and they may not necessarily be of the same claim scope. So you might have a stronger or broader patent in the US than maybe you were able to achieve in Europe, and so on. And so that kind of gives you a sense of the timeline and the process involved. And as you can see from that graphic there, the prosecution from filing your national phase applications through to grant can take anything from between 1 to 10 years. Typically, you're looking about 2 to 3 years, but some jurisdictions can take longer. There are also mechanisms for speeding up and slowing down the process, as may be required depending on your particular business requirements. So what are the requirements for patentability? When you're looking at your business and you're looking at the various aspects of what you're doing, how do you identify what it is that might be patentable? And first of all, I guess if there's anything that you're doing that you think is new over what you're aware of, the ways people are doing things at the moment, that's potentially something that you might be able to file a patent application for. When you're looking at whether something is new, it needs to be universally new. So it's not just new in view of any patent applications that might have been filed before. It's new in view of any blogs people might have on the internet, any prior uses by people anywhere in the world. Any piece of prior disclosure of an idea is potentially citable against any patent application you might file. So yeah, your idea needs to be new. And the second criteria then is that it needs to involve an inventive step. So inventive step is kind of a subjective test where whether something new or not is kind of more objective. Inventive step is whether what you're doing would be considered obvious to a person who's skilled in the art at the time that the invention was made. And that is generally assessed in view of prior art that an examiner has identified. It tends to be something that we recommend that companies don't worry too much about themselves, but it's often better to talk to a patent attorney who can give them a better sense of whether something is likely to be considered inventive or not. It's also something that is applied differently in different jurisdictions. So the threshold for inventiveness in something in Australia is a little bit lower than perhaps it might be applied in Europe. So it tends to be more difficult to get a European patent granted than perhaps an Australian patent granted. Then the third primary criteria is that your invention needs to be the type of thing that is considered patentable. Some things are just emphatically not patentable in some jurisdictions. For example, methods of treatment of animals and humans is just not considered patentable subject in Europe. Whereas it is in the US, you are able to secure patents for that type of subject matter in the United States. When it comes to software, although the lines of code themselves aren't considered the type of thing that's patentable, the functionality that's being performed by the computer program may well be patentable. Now, again, different jurisdictions apply different criteria when assessing this. Typically, though, what is worth considering is whether what you're doing is solving a technical problem. And if it is, that's generally a good kind of base to be able to stand, whereby you can make an argument that what you're doing isn't just mere automation or a scheme that's implemented in computer code, that it's actually a method that just happens to be in the software, coded in software, that actually solves a problem. Now, I'm just going to run through some common pitfalls pretty quickly that you should just bear in mind. The first is one of the most important one. It's prior self-disclosure. So I spoke about your idea needing to be new or novel over anything that's gone before you file your patent application. And that also includes any disclosure that you yourself might make. So if you go onto your website and start talking about your invention before you file a patent application, that is citable against your patent application. So the thing to remember is, if you think you have something that might be patentable, make a call as to whether you're going to file patent applications for it or not before you disclose it to anyone. Well, I suppose the caveat to that is it may be necessary for you to talk confidentially with people, and in those circumstances, it's probably worth getting a non-disclosure agreement drawn up if that is something that you need to do before you actually file your patent application. There is also a grace period in some jurisdictions for some types of intellectual property. For example, in Australia and the US, there's a grace period of a year for filing patent applications, which means that you can disclose your invention and still validly file for a patent application within a year of that disclosure. But you need to remember that those grace periods don't apply in all jurisdictions and for all types of intellectual property law. So, for example, there's no grace period for patents in Europe, and there is no grace period for designs in Australia. Lack of filing strategy is another pitfall. So you need to have a clear idea of what it is you're trying to achieve, what it is you want by filing patent applications, the jurisdictions you want to file in, how the timing should work out when you're going to be able to fund different filings. And all of these things need to be kind of thought about upfront and a decision made as to the best filing strategy to take. And then that should be revisited continually to make sure that it is aligning with your business requirements. Secret sauce, this point really ties back to that idea of trade secrets and potentially whether it's worthwhile keeping your invention secret if that is something that's possible to do, and not disclosing it to the public, perhaps because you might not be able to get protection for it, or indeed because you're very confident of the ability to keep it secret, and you may get an awful lot more longevity out of your invention by keeping it secret. So, for example, if you think of Google's search algorithm, they may not have been able to get patent protection for that, but they haven't disclosed it, they haven't filed patent applications for it, and if it's still valuable to them beyond 20 years, they effectively will have a longer protection than they would have gotten had they had a patent application. Similarly, the Coca-Cola recipe has been kept secret, kept as a trade secret, and by not having disclosed that, they've maintained that competitive advantage for a much longer duration. And finally, improper assignment of rights. So when you're filing patent applications, you need to make sure that you are that you're entitled to file the patent application. So, for example, if some of your employees have come up with the invention while working for your company should be entitled to the rights, but you should make sure that your employee contracts make it clear that any inventions that they devise in the course of their employment do actually flow to the company itself. You also want to make sure that if you have any contractors involved, that they have also assigned any rights in the invention to your company before you file your patent applications. Now, I will quickly run through a couple of things to think about before you meet with your patent attorney. So first of all, why are you seeking intellectual property? Is it something that you really want to do? How is it going to benefit your business? What is your budget? That is really crucial, because it will help your patent attorney figure out, or your trademark attorney, any IP attorney, help you figure out how to best spend that to put your business, to best protect the aspects of your business that need to be protected. You want to think about how you're planning on making money from your invention, which also feeds back into why you're seeking intellectual property for property protection in the first place. You want to consider which jurisdictions are going to be commercially important, and that feeds into devising a good filing strategy at the outset. So when you meet with a patent attorney, you want to be clear on what the problem your invention is trying to solve, and what previous solutions were available, and how does your invention work to solve that problem in a different way from those previous solutions. You should have a clear idea of whether you've disclosed your invention, and if you have, when and to whom, and what was the nature of those disclosures. Because again, that can feed into what your patent strategy should be. Also, who are the people contributed to the inventor, who may well be inventors, and making sure that you've got your assignments in place for those people, and who is actually going to own the intellectual property rights when you do file your patent application. So that is my roundup of navigating intellectual property. I'm happy to take questions now or afterwards. I don't know how you want to handle that.
Sure, we'll open it up for a few questions now, if anyone has anything.
Yeah, I think so. Hi, awesome. I can clearly see why there is such a thing as a patent attorney, because it'd be buggered if I'd wanted to go down that journey. Timing is my question, specifically around patents. At what stage is it advisable to sort of start to think about this? If it's, regardless of what the strategy is, if it's a protection or whatever it is, because obviously there are substantial costs in here, which can be prohibitive, right? But there might be reasons why you want to bring those forward and prioritize them. So have you got any gut feeling around that? Especially, we're all sort of mainly product companies here from a technology perspective. So from that side of things.
So basically, when you file your patent application, you're starting the clock ticking. So you file your first application, you have 12 months, you have to take the next step 12 months later. And once you've taken that next step, if it is filing that international application, 18 months later, you have to be ready to take the next step. So you need to be aware of the fact that that's going to start the clock ticking on all those downstream activities that need to happen. So you need to be comfortable that if you do file your patent application, you're going to be able to fund those activities as they happen and as you need them for your company. You also don't want to file your patent application too early. So when you file your first application, you need to disclose your application, or you need to disclose your invention in a way that somebody who picks up the patent application and reads it would be able to reproduce the invention. Now, that doesn't mean that you yourself need to have actually realized it yourself. You just need to know how it's going to work and be able to instruct somebody to perform it. Mm-hmm. You do have, within that 12-month period, so from your first filing to filing your international application or completing your application, you can add subject matter to your patent application. So if during that 12 months you file your first initial patent application for your broad idea, and then during that 12 months there's some tweaks or changes or modifications or extra things that happen, you can add those into the same patent application within that 12-month period. But after that 12-month period, once you've filed your PCT application, your international application, you can no longer add anything to that patent application, and you're really prosecuting that year's worth of work. Mm-hmm. And if you then come up with something further, you have to file a further application.
Further application. Okay. And so can you explain to me why, I've always sort of had this question, why they are published? Is it, what's the thesis behind that?
if you're doing a deal, basically. I mean, you get 20 years to control who can use. If you get your patent granted, you get a 20-year term to control who can use your invention. You can license it to people. You can stop people using it. You have that control. But there's a quid pro quo there. In exchange for doing that, you have to publish. You have to teach the world how to perform your invention, and that's contributing to the betterment of the world, and people can build on what you've disclosed there and maybe come up with a further invention, and that's the quid pro quo. And that, I suppose, one of the concerns about doing that is that you file your patent application and it's published 18 months after the first filing, so
Correct.
you don't know if you're going to get a patent granted or not.
Yeah. Yeah. Okay. Interesting. Thank you.
Great. Any other questions from the group?
I would just be curious about, I mean, to my mind, the first meeting that you sort of sketched out the basis of there, which is you'd sit down and you talk about whether or not you have a patentable idea, whether it meets those novelty requirements and so on. How much does it cost to go through that process? Because, you know, if we assume the answer is probably going to be no, but we're curious about whether or not that's the case. You know, like I know that when some lawyers will give you an upfront, you know, for free 1 hour. Is that enough time to make that kind of determination? I guess that's my question. How long does it take in general, and how much does it cost in general to come up with a gut feel for whether or not something's patentable?
I know that in our firm, and I would expect that probably in quite a few firms, that initial meeting tends to be free. I mean, if you decide not to go ahead, I think that it's unlikely that most firms would charge you for that. If you do go ahead, then you know you're working with them towards your filing your patent application. So I don't think you should be. I mean, if you're welcome to approach us, but I just ask, if you call up a patent attorney, ask them straight out if they're going to charge you for that initial meeting. Now, I guess what you should expect to get from that meeting is whether the type of thing that you're talking about is patentable, or the likelihood of it being patentable. They might not be able to tell you for sure it is patentable or for sure it's not. And that may be because in some jurisdictions, for example, if let's say your invention is a computer implemented invention, it's got a business method aspect to it, it may be something that is going to really struggle in Europe, and you're going to have difficulty actually securing patent protection in Europe. But there may be enough of a problem solution in the claim, in the invention, that you'd actually get it through, or there's a good chance that you get a US patent for it. So there's potentially not going to be a definitive yes, you should go, or no, you shouldn't go answer. And that's from the type of thing, whether the type of thing you're talking about is patentable. I mean, if it's simply displaying information, it's unlikely to be patentable anywhere. So there are types of things that just won't be patentable. In terms of meeting the other criteria of novelty and inventive step, at that meeting, or that initial meeting, your patent attorney is not going to have conducted a detailed search of the prior art. They're not going to have a clear idea of what's out there. They'll be going on what you're telling them. So you, having built this business, having an idea of what your competitors are doing, this is what you think is the new thing about what you're doing, and on that basis they can advise you. But it's up to you whether you then want to incur costs in having searches performed, or potentially do some searching yourself, or get a patent office to do some searching for you, and that might help better guide you as to whether you're confident that your idea is new or not. But often people feel that they have a good sense of what's out there. They might do a bit of searching themselves, and if they're confident that their idea is new, they might just go ahead and file patent applications.
That's very helpful. Thank you so much.
No worries.
Hi, Madeline.
Great.
Sorry. I had a question really quickly on sort of start date of protection. So, does the start date sort of start when you file your initial patent application, or does it start from, say, PCT, or will it just, you know, protection start from when each individual office undergoes their own checks and searches?
So every office will recognize the first filing date. So you file your first application, that is your filing date. That's the date that you have filed your documents with the Patents Office, and you've proved that you were that you had the invention at that date. So for all of the Patents Offices downstream, all the patent applications that you're going to be filing, your invention will be assessed against anything that was in the public before that date. So anything that happens after that date is irrelevant from assessing whether or not you're going to get a patent.
Okay, and what happens is, so after your sort of initial application, you know, you mentioned that you're able to sort of add on, you know, other sort of features.
Yeah.
Do those features get a different protection date, or do they all just rely on the same date?
No, that's an excellent question. They will get another date. So if you file your first application as your provisional application, it's only the subject matter that you file with the office on that day that gets that date. So if you don't file anything else and then you file your international application 12 months later, and when you're filing that, you add in more subject matter, that new subject matter gets the new filing date.
Okay.
And sometimes you might find that during that 12-month period, maybe you filed your patent application and 4 months down the track, you go, oh my God, we've got this great idea, this extra feature that we should add in. You should then consider filing a second provisional application to get that earlier date for that additional subject matter, as opposed to waiting to the 12-month period and getting, a date 8 months later.
Right.
But again, that's a strategy that your patent attorney should talk to you if you go about filing a provisional application. But that's a very good point. Yeah.
All right, great. Thank you.
Great. Well, great questions. Thanks, Madeline, for that quick presentation. I've also entered into the chat our contact point. So, of course, Madeline's details are right up on screen. I think we have Beata's contact as the initial contact for this. They are offering, these first initial consultations for our LawTech Hub residents. So if you do have more questions, please reach out directly.
Absolutely.
Thank you. And with that, I'll turn it over to Mark.
I'd ask Madeline to stop sharing, and I don't have a presentation. I'm going to talk about a grab or a hold all, a bag of things that we see with early stage companies, perhaps using the chat function or people waving. I'll move on more quickly or delve down more deeply depending on what people want. So this is going to be a high level overview of things that we often find when people come to us who've been working hard, and usually people are coming to us when they're raising their first significant raise. I do just want to make a couple of comments about what Madeline said, that I think if you've in an area where you think you've got patentable subject matter, it is highly desirable to have a relationship with a patent attorney who understands your space, because oftentimes I have seen you go and talk to a patent attorney with knowledge of the landscape, and they can actually make suggestions and point out areas that may not have been fully developed by other applicants, and will point to you where you might focus your attention. There is often the case that people who invent things tend to downplay the importance of what they've invented, and having someone who can challenge that and say, no, there is something of value there is good. And finally, even though all the research that Madeline and I would look at suggests that trade secrets are perhaps the most valuable items of intangible assets or intellectual property, investors still like the monopoly that attaches to patents. And so it is always worthwhile thinking about whether, in addition to protecting it for your business, filing a patent application can assist your negotiations with investors. So certainly encourage you to take up the offer of that initial free consultation to see if you've got anything that's worth looking at. And I don't get paid for that endorsement. So, okay, so let me start, and probably the best place to start is with the founders. And there's probably two, and I've got about 6 areas I'm going to talk about. So I'm going to start with founders. The issue with founders is that often things start because people have known each other in a previous environment, be it university or working. There might be a personal relationship, and the last thing they really want to think about is what happens if that good relationship breaks down. But inevitably, on the entrepreneurial journey, things don't turn out as planned. It takes longer. People have got different commitments, and can no longer survive on no income. So I would urge everyone, even at an early stage, to think about your relationship. And you don't necessarily need to go and see a lawyer, although it perhaps helps, because lawyers as a profession are mightily depressed and pessimistic people. So they will think of all the bad things that will go wrong and will perhaps temper your entrepreneurial enthusiasm. So just write it down. What if we need more money? Who's going to put it in? What happens if I need to go and get a consulting job to pay the rent? So write that down and have it ready. Now, there will come a time when you need to convert an informal document into a formal shareholder agreement. And particularly when you're raising capital, it's much better to go to the investor with a shareholder agreement that is investor ready. Most investors, if not all investors, will work with your agreement, but they won't insist on theirs. If you don't have one, though, they're going to put forward their agreement, and you're going to find yourself chipping away at all the clauses that are beneficial to the investor. If you have had a falling out and one of the founders has left, then make sure that's properly documented. In addition to any resignations or share transfers, it's always helpful to get some release from the departed founder to say they got no further interest. We have a matter at the moment where the raise is held up because there were 5 founders, 2 of whom have gone, 1 of whom's disappeared overseas and can't be found, and the investor won't close until we get a release signed. So we're struggling to make contact through Facebook and other social media channels to get the attention of that departed founder. The other thing with founders is vesting. I assume everyone is familiar with vesting, and that's the arrangement where shares that you might be issued and hold aren't yours until the vesting conditions have been satisfied. That might just be the passing of time, or it might be some outcome you've got to achieve. This is a common tool used by investors to hold founders' feet to the fire and make sure they remain committed. In fact, if you have a vesting arrangement in place between you as founders, then it'll be reset by the investors. But it's a good thing, again, with founders, because it does take out some of the emotion if someone can't stay on the journey. Yes, you've done a year, you'll get a proportion of the shares. You put the unvested shares back into the pool, and that's available then for us to bring another co-founder on. So much better you're thinking about those things now than we're trying to sort of backfill and find people when they've got no real interest in helping you. The next thing that we see that is poorly, sometimes poorly, not always, but often poorly managed, is the cap table. And anything to do with shares that you might have promised people informally, shares you might have, or options you might have promised to your employees, money you might have taken in on a convertible note or through a simple agreement for future equity safe. It really does help to have a well-constructed spreadsheet that allows you to identify those who've got an interest in your company. Any investor investing in your company is going to want a warranty or a promise from you that that's all true and correct. And if it's in poor shape, then you're the one that's going to have to make good anyone who comes along later claiming to have a share in the company. So make sure you've got a clear record of who you've promised interest to, and then that allows us to also model what happens then when you are bringing in an investor, and particularly for things where you haven't given shares but some interest that's convertible into a share, making sure that they aren't conflicting with each other, and that there's a clear understanding of when those things will convert ahead of a capital raise. The next thing is accounts. Obviously, with applications like Xero, it's very easy to keep accounts in a nice format where reports can be generated. But even if you're keeping accounts on the spreadsheet at an early stage, the key thing is to understand and have a clear view about money that you've contributed to the company. Is that equity you've contributed, i.e. money for shares, or is it a loan to the company? I have seen one capital raise fall over spectacularly where a founder disclosed a week before close that they were owed $100,000 by the company, which they had contributed by maxing out on 5 credit cards, that they were now being sued and they had to get that money repaid. That came as a complete shock to everyone. And the deal fell over because the investor lost confidence. So it's understanding what cash you put into the business. Most investors will say, well, bad luck, that's money you've put into the business, that's part of your contribution for the shares you've got. But sometimes, you might have had to put a security deposit down or something where it's actually appropriate that become a liability or an obligation of the company. Again, it's not necessarily dotting the I's and crossing the T's at the time you put the money in, but having a clear record so that when you come to raise money, you can articulate an argument as to why you should be paid that back, or you just accept the fact that you have lost that money, but at least then you can tell the investor, well, that's cash that's gone in addition to whatever sweat has gone into developing the business. It's when people don't know or suddenly raise things late in the piece that it causes a problem. One thing I'll mention, and this is sort of just to amplify again things that Madeline said, we're finding, particularly now that there is at least one US fund that is willing to invest directly into Australian companies, but even amongst Australian investors of any size, is that there is a concern about use of open source software. Nothing wrong per se, but what the concern is can you identify what you've used, and can you identify the conditions attaching to that use? And clearly investors are worried about you using open source software where there's an obligation to republish. So picking up on Madeline's point about keeping a record of the software you develop, which you presumably do through GitHub or Bitbucket, one of those applications, keep a similar record in relation to your open source software. We did a transaction, it was an exit, so this was some 10 or 12 years after the application or the platform was built. It was a KKR-backed company that was acquiring, so KKR were in the background, no doubt driving the due diligence. We got a copy of the sale agreement back with a note. I don't think it was meant to be in there, but it showed how important the issue was around the qualification we'd given on the open source software. The comment was, is this a deal breaker? Because it was 10 years previously, the company had great trouble in identifying actually what they had used, how they'd implemented it, and what the terms were. So again, part of our job as the commercial lawyers is to think ahead to those major events in the company's life and trying to make sure that what you're doing now doesn't kill you with admin, but also means that you're not facing problems or a reduction in value when you've got a chance to exit. The other thing there is just around the ownership of the IP. So Madeline and her team can beaver away and get you lots of nice patents, but there will be an inquiry in due diligence made on how the company came to own that intellectual property. An employee might have developed it, a contractor might have developed it, you might have bought it in a transaction. So I really would encourage you to adopt the suggestion made by Madeline that you have a register of your IP, not just the code, but any other bits of IP you're using in your business, so that you can demonstrate that the company got it because it was built for us by an employee, and here's the employment contract. It was built by us, for us by a contractor, and here's the contractor agreement, each of which will have an IP assignment clause in, or we acquired it and here's the sale contract. We also do some entertainment work, and we have exactly the same problems with scripts. for films which might go through 3 or 4 hands before they get into the hands of the producer that makes the film. It's exactly the same issue. It's another sort of element of copyright, and people who are, investing money will want to know that there's no risk of someone coming along when they see the company's made some money and making a claim to have some interest in that, or to get an injunction to stop it happening. I'll keep going. If there's any questions, let me know. The next thing is the company itself. So I think everyone here has got a company, and that's a very good starting point because it's a first line of defense against personal liability. The company is also a single place that all the IP can go. Without a company, the IP might be held in people's names or may not have been properly assigned. So having a company is a good start, but you need to make sure that company is complying with the law. And one of the laws that you have to comply with is that you have a company register. So it's very easy these days to go online onto the government website and incorporate a company. You get an ACN, you've got a company, and wow, you're in business. But when an investor comes to look at your business, or a buyer, they're going to want to look at a thing called the corporate register. And the register is a record in various parts of important things relating to the company. Who owns the shares? How did they acquire the shares? Were they issued? Were they transferred? Who are the directors? Who holds any other interests in the company? And because you don't get this when you incorporate online, and I think even with if you use a third-party service provider, they offer this as an optional extra. It means that when we're doing a capital raise, all of a sudden we have to backfill the register. Now, if you've done nothing in your company, still you as the sole incorporating shareholder and sole director, that's relatively easy. But if you've had some people coming and going, some investment, it's hard because that all has to be built up. And most people object to paying money for something that doesn't then immediately provide some value. So I would encourage everyone to go and have a look, see whether they've got a register, and make sure that's kept up to date. The trouble is, even with those companies that provide one, often it's done as a PDF and it's not very easy to update it electronically. But just be aware that you should have one of those in your kit bag before you come and see us as lawyers if you want to do a raise. Next thing on this very quick excursion is employment. And there are probably 3 or 4 things that investors are going to look at here. Firstly, if you've made a lot of use of contractors, they will investigate whether those people are genuine contractors or really whether they've in fact been working for you full time over a period of months, if not years, and whether they should be treated as employees. Because if you've paid someone as a contractor, even though it might be easier in a startup world, you haven't probably paid superannuation, you haven't paid workers' compensation, payroll tax probably won't be a problem at this stage, and you may not have deducted the right tax. And again, investors will be worried that the ATO may come and do an audit and levy penalties and additional money that you have to pay to make up for those things. Okay, I've just seen a message. So it's a matter of making sure that you've got relationships documented and you're ready to answer it. When you're raising money, it's probably something that you can say, now we have the money, we can sort that out and fix this all up. And that usually addresses the problem. When you're selling, you usually have to, some accountant, usually from a big firm, will go through and work out what money is potentially at risk. And we'll deduct that off the amount they're paying for the business. So just be aware of that issue. Another issue is for employees, particularly the founders who may have been unpaid. It often helps particularly in an exit. And I know this is a long time off, but if you can start your employment relationship, because it starts to accrue leave and long service leave entitlements, and after 10 years that might accrue another $50,000 to $100,000 that you get in cash. So it's worth starting the employment relationship sooner rather than later. The problem is, if you've been put down as an employee paying yourself $1 a week, you then put yourself in breach of the Fair Work legislation. And while you aren't going to go and report yourself to the Fair Work Commission, an investor might ask questions. So the way we usually handle that is to ensure there is something in place that releases the company from any obligation to pay, but still allows the founders to claim that they were employees maybe 1 or 2 years earlier than they might otherwise. And as I said, no immediate benefit from that, but it does help if in 5-10 years' time you're doing an exit.
Hey, Mark.
Can I ask a question about that quickly?
Yes.
Is that generally done in a separate document or as part of the employment agreement for the founders?
Yeah.
Actually, sorry, I'm going to interrupt for a minute. So I know we're butting up on the hour. For those who do need to drop off, please feel free. I've pasted the contact information for Mark. We'll be distributing some of the information later from thank you, Madeline and FB Rice, as well as Mark. I'll ask him later for, he did a nice presentation for us once before, and I'll ask if we could pass that around. I'm happy to stick around for more questions, and please do continue.
Okay, I'm happy to keep going, so yeah, keep the questions coming. And I think the other thing, just in, sorry, the question you're asking is, I would probably do it in the same document. So you can say it was always the arrangement that the employee would release. Now, look, there's always going to be arguments that that's not enforceable, but I think most investors who invest in early stage companies will recognize the reality and will give it a tick and say, let's move on, and then would probably ask you to enter into a new employment agreement once the capital had come in and the company's in a position to pay the appropriate salary.
To meet the minimum wage. Yeah, great. Thanks for that, Mark.
And the final thing on employees really is in this sort of talent war where you may be poaching people from other businesses, or so where you're the person recruiting, is to make sure that you don't find yourself getting a rude letter from the person's previous employment saying they're infringing some restraint. We probably get half a dozen of those cases a year. It might not sound a large number, but if you've got to spend, $10,000, $15,000, $20,000 fighting that, that's a cost that most early stage businesses can't afford. So it's sometimes worth just asking the employees you recruit to have a look at the relevant clauses of their previous employment contract. And likewise, you should be thinking about appropriate restraints in your documents, so that if someone leaves you and goes to a competitor, then you might have some ability to limit the damage they do. Courts don't like restraints, but there are ways of drafting them to give you some measure of protection, particularly around someone leaving and then stealing other stuff, and then certainly talking to clients. Final thing is with the increasing emphasis on data and data security, to the extent that your business has personal information, is controlling third-party data, larger customers are going to want to know you've got insurance. Investors are going to want to know you've got insurance. So good to get a relationship with an insurance broker as well, even if you've held off effecting the insurance because the premium's too much until you've got some capital. You are able to get a quote, and to, it'll be a condition of the closing of the raise that you effect the insurance, that you put that into place. Stephen, that was very quick, I know, but probably best if there are any questions from the remaining people that I answer those, and I'm very happy if those who've had to leave have any questions, they can just email me them.
Yeah, for sure. Just we can linger on Brian and Oliver. Anything kind of burning off the top of your tongue that you'd like to ask Mark?
Nothing springs to mind for me. I mean, sorry, lots springs to mind, but nothing that is generic enough that Brian has to sit through the answer. So perhaps what I'll do is I'll take Mark's contact details away, and then if something comes up, we will definitely reach out to you.
Yeah, and I'm happy to, just to make it clear, have that free hour. So if there are things you want to have a conversation, don't be frightened. I'd rather talk about it and either talk you through it and find a solution, or work out how you might deal with a problem.
That's very generous. Thank you, Mark. I will take you up on it. So be careful what you wish for. Wonderful. Thank you.
Good, Mark, and you have to update us with your new latest contact details.
I'll do that. Okay.
Great. Well, Mark, thanks for your time. Everyone else, thanks for joining in. And we will have our next session, I believe, in 2 weeks' time. So stay tuned for that. I hope they're as good as Mark and Madeline.
And good luck with the program, guys.
Thanks everybody.
Thank you.
All right, bye.